Good morning, everyone, and welcome. I'm going to give it just a moment for our attendees to cycle in, and then we're going to get started. Okay, hello again, everyone, and welcome to Protect Your Assets from Lawsuits with the Right Entity Selection for Your Business. We are so glad that you joined us today. Now, before we get started with the presentation, there's just a few quick housekeeping items. This webinar is being recorded, and you'll receive a link to the recording emailed to you later today, so be on the lookout for that in your inbox. This webinar will run 50 minutes with 10 minutes Q&A at the end. If you have a question for our presenters, please put it in the Q&A box located in your Zoom toolbar. To find your Zoom toolbar, just hover your mouse over the top or bottom of your screen, and the toolbar should pop right up. Look for the Q&A icon. Our webinar's host, LSL partner Dave Meyer, unfortunately cannot be here today due to an unforeseen circumstance, but we still have our fantastic speakers, Harry and Brent, here to present to you today. So without further ado, I'd like to introduce them to you. Harry Barth is the founder and senior managing partner for Barth Calderon, LLP, and is the co-author of the book, Planning Today for All Your Tomorrows. He is a nationally recognized speaker on estate, business, and asset protection planning to many incredible organizations across the country, including Vistage International, Women's Presidents Organization, Young Presidents Organization, Tiger 21, Quaker Oats, Entrepreneurs Organization, California Society of CPAs, and many more. Harry has over 40 years of experience counseling business owners and their families, corporations, and franchisees nationwide. Harry has distinguished himself by being an asset protection advocate, and his workshops have helped thousands of families and businesses protect their assets they have worked so hard to build. Brent Honea has spent over 20 years in the investment industry helping families and business owners to properly plan their finances. He enjoys communicating complex subjects of estate planning and asset protection in a way that his clients can understand and appreciate so that they can go on to manage their lives with confidence and security. Brent thrives to build lifelong relationships with his clients to ensure that their plans are up to date when they need to be implemented. All right, take it away, Harry and Brent.
Okay, well, thank you, and good morning, everybody. It's great to be here once again with all the people at LSL. I hope this morning, in the short period of time that we have together, I can kind of make a deal with you, and the deal is as follows. You know, it struck me after been speaking around the country for close to 40 years, and it struck me just the other day, who doesn't want to protect their assets? I mean, really, think about it. Who says, no, I want to leave my assets vulnerable to predators and creditors and overly zealous plaintiffs and their lawyers? Who wants everything that I've worked so hard for to be easily taken away? And who wants to be mired in a long lawsuit if not necessary? I think everybody universally would like to have as much protection around that which we've worked so hard to build over the years. So what's the equation? So the question is what does it cost me to do so? What are the rules and restrictions that I have to follow in order to gain that protection? And what are my alternatives? And it's in that area where people sometimes make a decision, well, it costs too much, I have too many restrictions, I'll just take the risks that's associated with it. I guess my job here today is to try to convince you that it's better, really, to take the time, analyze, and protect your assets properly. Now, even though we only have 50 minutes today, Brent and I and the team will be available to provide complimentary consultations, as we always have, for LSL webinar attendees. Leave your checkbook at home to answer further questions that we won't have time to do today. So, first of all, what is asset protection anyway? So we're going to spend the first 20 minutes or so together laying the foundation of why this is absolutely necessary. Well, all it is really is arranging our assets through the use of entities, which we're going to learn about in the back part of today's workshop, arranging our assets in such a way as they are less susceptible to overly zealous plaintiffs and claimants, and trying to level the playing field. Over the years, the playing field is not level. Once you're sued, you lose. And it's really problematic. So we want to level the playing field a little bit to encourage quick settlement, drive people towards insurance, and get things done. I think that's critically important. Now, asset protection planning, really is not something that's strange or different. It's not hiding money away in an island somewhere or doing things secretly. That has no part, or evading taxes. That is no part of asset protection planning whatsoever. When you think about it, when you're doing estate tax planning, what are we trying to do? We're trying to minimize the tax that's taken by a creditor, United States government. We're trying to minimize our exposure to courts and lawyers. When we do tax planning at the end of the year or during the course of a year and take various different tax strategies, what are we doing? We're trying to keep as much assets as we possibly can for ourselves and less for the state and for the federal government. And when we do insurance planning, buying insurance, whether it be life insurance, property casualty insurance, umbrella insurance, which we're going to talk about in a few minutes, there's definitely asset protection planning that's involved with that, finding a way to pay for what happens in an inevitable or potential liability. So an asset protection is not about the reduction of risk. We all have risks because we drive cars, we may own properties, we may be officers and directors and businesses, we have children, big dogs, there's just so many areas of risk. I'm not going to waste our valuable time going through that. Asset protection is not about eliminating risk. Asset protection is about doubt as to collectability, so we can have a quicker and easier result in settlement. Now, in laying the foundation of why this is so critically important, there are a few axioms that need to be talked about every single time I have this discussion. So the first axiom of asset protection planning, and the most important one, is that you really should not be engaging in asset protection planning after the events have occurred. Now, we get calls, Brent and I get calls all week long. We call them hair on fire calls, right? People that, bad things have happened. They've had a terrible wreck on the freeway. People are injured. They've had a rental property where something has gone absolutely wrong. And the list goes on and on and on. Now they're concerned that either they have inadequate insurance, not enough asset protection, and they could lose everything that they have earned. So nowadays they call the lawyer and say, what can you do to help me? So understand that there are little things that we can do in circumstances like that, but those are more like speed bumps. But if we work preemptively and proactively with you, when there are no clouds in the sky, in planning for a potential future liability, we can build substantial roadblocks and substantial walls around your assets to keep them protected. And that is our goal, and a goal in what I'm trying to convey to you today. Very, very important. And people will say to us, we had this thing that's happened, last Saturday, and we haven't been sued yet. All right. So a lot of people believe it's when they're sued that the legal action begins. Ladies and gentlemen, it began when the accident happened, when the facts that gave rise to the cause of action, that's when it begins, not when the legal action could take place a year and a half later. We're going to look back at that action. Action that you take after the events arose could be considered what is known as avoidable conveyance. It could be unwound. Creditors have very, very strong weapons when we're trying to prevent them from reaching your assets after the events have occurred. So number one, most important, let's take a look at everything, see where the vulnerabilities are when we have no problems, and let's get some asset protection planning in place. Number two, a very important urban myth, so to speak. I don't know where it comes from, but it's an urban myth. And that's the living revocable trust. That's very, very important trust that's used to sometimes help with some estate taxation, helping to avoid probates, laying down the legacy for the family. That type of trust has absolutely zero asset protection. Now, sometimes it's even in a name. So we could have, Jill's Living Revocable Trust, or we could name it Jill's Asset Protection Trust. At least it gives a creditor a pause to think that maybe there is some asset. We've got to get in their head, put a little fear to try to get things resolved easier. But for our purposes, that trust, all as important as it may be, has no asset protection whatsoever. And we get, questions and inquiries from people from time to time and saying, well, if it doesn't give me any asset protection, why do I have it? It's for all the other reasons that I articulated, that asset protection not being one of them. Now, here's the next one is important, and it'll become very important as we get into entity structures a little later on in the workshop. And you tell me I have insurance for that. So I had bought umbrella liability insurance. Personally, I have umbrella insurance, on my rental properties. I have umbrella insurance on my business. I have a lot of insurance. So insurance, make no bones about it, is a very important and key component part of asset protection planning. The insurance companies traditionally will hire lawyers to help defend you if it's within the scope of the policy limits. And it's the pot of gold to drive the plaintiff to satisfy a claim. God forbid we have liability, but it's not the know all end all. That is a giant mistake, and I want to make that case to you right now. So people come to my office and they'll sit with Brent and I, and they'll say when we go through our analysis with them, oh, we bought $3 million worth of umbrella liability coverage. Of course, it's not very expensive, as we all know. We got $3 million of coverage. What are they really saying to Brent and myself? What they're saying is that they throw their chest out and say, we believe that we will not have a lawsuit that will result in a liability greater than to the $3 million. And if we do, the blood-sucking lawyer will take that policy for $3 million and leave my personal assets alone. This is a mistake. This is not going to happen. There is no relationship between the amount of legal liability and the amount of insurance that you have. If we have too much, we have a target. If we don't have enough, we have the inability to pay. We can have a $3 million policy, and maybe we think that's enough, but it's a $5 million liability. Where's the other $2 million going to come from? So more often than not, we see claims that are in excess of the amount of liability insurance that you have. And what happens is the lovely insurance company writes us a letter and says, dear Brent, it appears that this liability that you have is going to exceed the policy limits that you have. I think you should contact your lawyer. Well, I think that's a little late in the game. So that's number one. We may not have enough. So it's the marriage, ladies and gentlemen, between appropriate legal process and insurance that begins to develop the protection that we so sorely need. Now, the other thing that's really important to understand when people talk about umbrella business coverage, umbrella landlord-tenant coverage, umbrella personal liability, what they fail to understand is that it's not everything that falls out of the sky. There are 60 pages of covenants, conditions, and exclusions. And many people receive something which is known as a reservation of rights letter. The insurance company says, hey, look, Brent, we'll defend you, all right? But if you're found liable for this particular thing under paragraph 3.6.25, page 12, subparagraph 2, that is an excluded cause of action. We don't pay for that. So we'll defend you, but if you're found liable, we don't pay for that. So, for example, we'll defend you in a DUI, all right, the case, but if you're found liable for DUI, there is no coverage. So we have that. So there are many, many, many causes and exclusions. For example, punitive damages, exemplary damages, special damages are not covered. For example, people may have an umbrella employee practices liability coverage, but it doesn't cover wage and hour. All right. We may have landlord-tenant coverage, but it doesn't as a mold exclusion if we have any mold. All right. Or a rodent exclusion if we have a rodent problem and we have some kind of tick or Lyme disease. God knows what it may be. There are many, many, many exclusions. So insurance is important, but that's not the know-all, end-all. So it's very important that we understand that because so many people would say, oh, we'll just turn around and buy a bigger insurance policy rather than deal with all the things we need to protect our assets properly. That's an error. I'll be emphatically about that, but that's an error. So let's take a look at some statistics. Statistics are very important here, and the analysis of these statistics are very, very important because when we get to the actual meat of the seminar, which is this choice of entity, we have to remember what we're facing. These are all the things that I'm talking to you about. Now, the reasons why entity structuring is so important because entities are the backbone of asset protection planning. But let's take a look at some interesting statistics. Whenever I speak about this around the country, people are just amazed by these numbers. So we'll use a base year of 2019. All right. 2020 was an aberration year. Close, courts were closed, a pandemic was going on, and now we're pretty much getting back to business as usual. There were 50 million lawsuits filed in the United States in 2019. I mean, think about that. 50 million lawsuits. There are 300 million people got 50 million lawsuits. We are a litigious nation and full of lawsuits. That's an amazing number. Now, it's not that amazing when you think about every tax action, every environmental action, every climate action, every immigration action, every divorce action, criminal action, tort action, contract action. Every time we ask the judicial branch of government to do something, to intervene, to help arbitrate a dispute, it begins by filing a complaint, in the judicial system. So there are 50 million of those that happen every single year in the United States of America. But there's a statistic that we're going to analyze together before we get into the meat of stuff that's even more amazing. And that is, and when I learned this years ago, it absolutely floored me, and it might floor you, that 95% of all the litigation in the entire world occurs in the United States of America. Only 5% of the litigation occurs outside the United States of America. Wow, that is a really, really interesting statistic. But it's a statistic that we need to analyze because it's the heart of the reasons why we need to do the things we need to do, and that we're going to talk about today. So why would that be? Well, some of it, two of them are kind of a broad brush. One is that we are the largest and remain, at least for now, the largest economic engine in the world. We have more entities and LLCs and corporations and limited partnerships and businesses and commerce and we're a nation under laws than any place in the world by far. So therefore, we would anticipate that most of the litigation over rules and regulations would happen here in the United States. Matter of fact, many foreign countries do business here as Delaware entities. And so therefore, most of those things are litigated in Delaware. So there's just an awful lot of that. And two, over the years, which is critical to our conversation today, as a societal norm in the United States is we've learned as a society not to take responsibility for anything. So I ate too many McDonald's hamburgers. It's made me too fat. McDonald's is at fault. We're smoking cigarettes. The tobacco companies are at fault. All right. We were, no matter what we do, we were drinking the water at Camp Lejeune, and the government's at fault. We took a bad pill. We used the weed Roundup, weed killer. It goes on and on and on. It's never our fault. If we fall asleep behind the wheel, our employer kept us at work too long without an appropriate and proper meal break. So we're always looking to blame, and we're always looking to recover. It used to be we earned our money by hard work. Today it's an inheritance, it's gift, or by lawsuit. And some people like to see if they can hit the lawsuit lottery. So it's just been ingrained. But there's some other reasons too. I practice in more than one country. And we are, as the United States of America, probably one of the only, if not the only country in the world that has a contingency fee legal system where victims, we'll call them, or plaintiffs, partner with law firms. I call it an unholy alliance between then law firms, and to bring large lawsuits, whether it be class actions, mass tort actions, personal injury actions, so on and so forth, without having to pay anything. And if they recover, the law firm picks up 30 to 40% of everything that they recover. Now, initially, that was a good idea. And because the legal system is expensive, we all know that. And so by allowing plaintiffs to partner with law firms, it was a way to bring to low and moderate income families the way to get the value from a much more expensive law firm than they would otherwise be able to get to get their rights. And, I think that was a very noble and good purpose. It's turned into a multi-billion-dollar industry of mass torts and class actions. It's PAGA claims, private attorney general claims for wages and hours in California specifically. We look at that. It's turned into so many different, that we've seen the mass tort claims against the Catholic Church. It just goes on and on and on. And it encourages, in many cases, litigation rather than discouraging litigation. So in many other countries, if you need a lawyer, you got to pay for a lawyer. Now, so that's one thing that encourages it. The other thing, too, is in America, we have what we call the American system of legal fees versus the one that's used traditionally around the world, the British system of legal fees. So inherently in the British system of legal fees, what it basically says is that, look, if I bring an inconsequential, bogus lawsuit against Brent, there are no contingency fee defense attorneys. Brent's going to have to lawyer up and pay for a lawyer, even though my claim may be really frivolous. In most countries around the world, if I'm unable to make my claim, I have to pay Brent's legal fees. All right. And if he sues me and he can't make his claim against me, all right, he has to pay my legal fees. And that discourages frivolous litigation. In America, absent contractual provisions that change it to any other way, that's not the case. And we see so many of these settlements, cost of defense. It was going to cost me $300,000 to defend this. So between myself and the insurance company, we gave the plaintiff $300,000 to make them go away. And it just encourages that over and over and over again. I would think that, let me give you a quick example on a potential client that we're dealing with right now. He sued his partner for fraud. It's been going on for about 3-4 years now. The other person has rung up close to $2.5 million worth of legal fees. And if he can't make the fraud case, and he didn't do it, he wasn't sued. He didn't do anything wrong. He's suing his partner for fraud. If he can't make the fraud case, he's going to have to pay the partner's legal fees of close to $2.5 million. It's kind of like a boomerang that comes right back. What an awful result to be defrauded and then wind up having to pay $2.5 million worth of legal fees. Of course, his choice was not to bring the case whatsoever in the first place. So that's how prevailing party works. And last but not least, in this one sequence, we have something special in a good old US of A, punitive special exemplary damages, which doesn't exist pretty much at other places in the world. And that's where, ladies and gentlemen, they turn around and say, hey, what you did, well, maybe you were not negligent, maybe you were grossly negligent. So you had $300,000 worth of damages, but we didn't like your conduct. Not quite criminal. So we're going to hit you with $1 million worth of punitive damages using the civil legal system to punish you. So we can begin to legislate from the jury box. Oh my God Almighty. And then people say, well, how much does my insurance company cover that? And the answer is zero, because it sure isn't punitive to you if it's being paid by State Farm or Allstate. So I think that it's really important to understand when you add up the societal norms, you add up the contingency system, you add up the way that we pay legal fees and the causes of action that blow up into these large things, it just opens the floodgates to potential litigation. Now, we have to understand that in asset protection, one of the things that we do is we can't change these things. These are the way they are. So the risk, when you look at it, the risk of owning real property, the risk of being in business, especially in California, is pretty high. So you get high risk. What asset protection does is it brings those risks back to normal. So we can do the things we need to do. I have a business in California. All right. Many of you may have a business in California. The risk is too high. But with appropriate asset protection, we can enjoy doing business in California because we rest assured that our assets are relatively well protected from the claims of third-party creditors. And also understand in the judicial system that every argument that we create for you, every wall that we build, every barrier that we put in has settlement value. Because what is a good asset protection plan? It's not going into court and fighting for every last tooth and nail down to the last penny. You're there because you had liability. All right, there was a real liability. Like I said, my protection has nothing to do with your liability. Mine has to do with doubt as to collectability. So really what we want to do is we'd like to get this thing settled at a much less cost than it would have been with the absence of the asset protection, and much quicker. Why quicker? Because unless any of you have ever been involved with the legal system, it's not fun. Having depositions taken is not fun. Having judgment debtor examinations are not fun. So if we can get this thing over quickly, we are a whole lot better off. Okay, so I think we set the background somewhat when we talk about the reasons for asset protection. I could spend the next 2 hours talking about that, but I'd like to focus in on some of the headlines that we spoke about and why you signed up for this workshop and seminar with us today. So, and that is entity structuring. And entities, well, we'll call it entities and trusts. We may talk a little bit about trust at the very, very tail end of our workshop today. But we talk about entities, well, the ways in which we do business, I think is critically important for our asset protection and the nature of our asset protection. So let's talk about the ways that we can do business. We could do business as a sole proprietor, and we'll come back and talk about that. We could do business as a general partnership. We could do business. These are all legal forms of doing business in California as a limited partnership. We could do business as a corporation, whether it's a C corporation or an S corporation. Just let's make that clear right now is irrelevant. That's the form, the way in which it's taxed. But a corporation is the legal structure that we can do business as a corporation. Many of us do. A good percentage of people in California or business in California are California S corporations. And we'll talk about the issues associated with those. We could do business as a limited liability company. So we're going to kind of walk our way through some of them. Two of them we'll dispense with relatively quickly. So let's talk a little bit about sole proprietorship. You just pop up in business, you don't have anything to file for anybody. You just engage in business, Jack's plumbing, and Jack goes out and does the plumbing and does what he needs to do. And everything's recorded on the Schedule C of his tax return. It's a sole proprietorship. And so for asset protection purposes, ladies and gentlemen, there's absolutely none. So Jack is personally responsible for everything that he does for his employees. He's personally responsible for the work that he does, personally responsible for everything. There is no entity whatsoever. So people ask, where does that liability end? Well, let me make it very simple and very draconian for all of you. It ends with Jack's bankruptcy. So if he does some plumbing work and that plumbing fails and it floods someone's house, and as a result of it, someone's electrocuted because they stepped in the water, and Jack is sued for several $1 million, and he doesn't have adequate insurance, Jack could lose his home, depending on homestead exemptions. He could lose everything in the bank. He could lose his future income. He could lose his rental property. He could lose everything that he spent his entire life building. Not a real good working model. So let's dispense with that right away. I don't think that if we're going to be in business, I don't think being in business as a sole proprietorship makes a lot of sense. Not from an asset protection point of view whatsoever. But there's one that's worse than that, and that's a general partnership. So Brent and I meet up and we kind of shake hands and say, we're going to start a manure removal company, Harry and Brent's manure removal company. We shake hands on it and we go to work. We're partners, Brent and Harry. That's a general partnership. Now, in a general partnership, which doesn't require any special forms with the government, we may most likely and more likely will file a partnership tax return. Both Brent and I have personal unlimited liability to the extent of both of our net worth. So I'm liable for all of Brent's activities in business, and Brent is liable for all of my activities to the full extent of our net worth. So the same thing, we lose our house, lose our car, lose our sheep, lose our cows, lose everything that we have worked all our lives for in doing business. That is probably worse, at least as a sole proprietor, you govern your own. But now if you have 2 or 3 general partners, that doesn't seem to make much sense. And we don't see very much of that anymore. However, every year we encounter several family businesses that are still doing business as general partnerships, and we try to explain the liability that's associated with that and have them do business in a more protected fashion. So let's continue on a little bit. And there's another form of partnership in California known as a limited partnership. Now, a limited partnership does provide some reasonably good asset protection. We won't talk about jurisdictions right now because those jurisdictions we'll talk about when we go through limited liability companies, which is the Swiss Army knife of asset protection and utilization in a few moments. But a limited partnership, Brent and I could form a limited partnership. I could be a limited partner. Brent could be a limited partner, and our liability rising up from the operations of that limited partnership is limited to our investment in that limited partnership. So if Brent put in $100,000 and I put in $100,000 as limited partners, and there's a lawsuit to the limited partnership, the maximum that we could lose as limited partners is the $100,000 inherently that we invested in that business and the value of that particular business. Not bad. Files a tax return, but limited partners have a couple of things that we need to be concerned about. So one of them is that in a limited partnership, we have to have something which is known as a general partner. So the general partner, if we want to look at it this way, general partner is the brains of the business and the limited partnership is the body of the business. So all of the business decisions, actions, the boss of the limited partnership that makes the daily decisions about everything to do with the limited partnership is done by the general partner. The general partner is just like our general partnership. It has unlimited liability to the full extent of the law. So once again, if Harry and Brent's limited partnership, if the general partners are Harry and Brent, they will sue the limited partnership. That's our $100,000 each. And then they're going to sue the general partners who make all the decisions, Harry and Brent, and we can lose our houses and our bank accounts and our real estate and everything else that we own. So what we have to do is we need to form an entity as a corporation or a limited liability company to act as our general partner. So now we're maintaining two entities. We're maintaining a limited partnership and we're maintaining our entity level general partnership. Not a bad structure as long as the general partnership is structured properly and is strong enough. Has some tax advantages associated with it. Very, very important. But remember that limited partners can have no voice in management. And one of the things that lawyers look for is, did the limited partners have any voice in management? Did they help make decisions regarding the business? And if the answer is yes, it turns them into general partners, and they could have unlimited personal liability. So as a functionality, limited partnership's not bad, but we have to be very, very careful as we look at it with you that the general partner is structured properly and can withstand attack. Then we get to a corporation, and I think a corporation we should take a few minutes of our time to talk about it. So a corporation is a legal entity that really was designed primarily for asset protection. It's an asset protection entity. It's an asset protection tool. It was designed many years ago, actually designed at the time of the Industrial Revolution, so that when we invested in Ford Motor Company, if a Pinto blew up, we wouldn't lose our house. So today, the vast majority of corporations are small businesses. And so the corporation itself is a asset protected entity, and the liability for the maximum liability that should be for any corporation for a corporate liability is the value of the assets that are inside that particular corporation. So if I have a liability, a corporate liability, coming from the operations of the business, I will sue that corporation. And if it's structured properly and run properly, very important, it's the assets that are in that corporation that are subject to that claim. But Harry and Brent's house and our bank accounts, our other real estate, and even our other businesses are not subject to that claim. So But in order to get that, a couple things have to come to play. So first of all, we have to follow all the formalities about books, records, minutes, shareholder meetings, board of director meetings. These are not things that are optional. They're mandated by the state to get them done. And the other thing too is we got to look inside our entity, because here's what we see. And many of you may have had we'll put it subject to this particular problem. So we look at a business owner. Brent and I look at a business owner. They come to us and we're doing some analytical work to determine their vulnerabilities. And we see that they have a corporation. It's an S corporation. Could be a C corporation, doesn't really matter, but it's an S corporation in this particular case. And that corporation, a successful business, has is worth about 85% of their net worth. So that business may be worth, $10 million. And then the rest of their assets are maybe $2 million. Because they got $10 million within the shell of this business. And we look inside this business and we look at everything that's inside this. So if we have a corporate liability, that pretty much wipes out their net worth. Inside the corporation, there may be several different lines of business. They may own a bunch of equipment. They may have a bunch of intellectual property, patents, copyrights, trademarks. They may have a large bundle of stocks, bonds, and cash, excess needed for working capital, large amounts of inventory, accounts receivable, and the list goes on. And they have all of these assets in one box. So if I have a liability to that one box, that wipes out 85% of the net worth. Now, that doesn't seem to make much sense to me either. Maybe if we took a look inside, maybe we should divide that, if we can, into an entity, a subsidiary entity that has the equipment, another subsidiary entity that might have the intellectual property, another subsidiary entity, if we wanted to, that might hold the finances of the company, and another one that's dealing with the operations, and keep them separate as best as we can within that entity. And hopefully a liability to one of those substructures doesn't take down the other structures. Hey, at least we have an argument. An argument is very, very, very important here. So we have to take a look inside our entities that we have. But that's not the tail of the tape when it comes to corporations. So assuming that we've done everything right, we won't get out, the old cliche that you've heard, piercing the veil, may not necessarily come to play if we've done everything right. If we haven't, we go right through to Harry and Brent and take our houses and our cars and everything else that we have to satisfy the claim. So beyond today is what do you need to do to run that properly. But the strong consideration is also not to have all our eggs in one basket, and to design that basket to be able to more withstand attack from within. But this isn't the real problem with corporations. And it was one of the things that was highlighted in call it the billboard for today's webinar. And that is a liability that comes to the owner of the corporation. So this is not an inside liability occurring at the entity. This is a liability. Harry's wife has crashed the car on the freeway and injured a number of people. I own a corporation, whether it be S or C. Is California, that crash became a community liability. I had $1 million worth of umbrella liability coverage. Looks like the liability is going to be 3.5, 4 million, maybe more. Could have had a death. And now that liability comes to Harry and his wife. And we now look down to see what assets, in addition to the insurance, we can reach in order to satisfy that claim. So I look down and there is that $10 million corporation. All right, that's full of stocks, bonds, cash, inventory, intellectual property, trademarks, all the various things. It's a very rich entity or entities. I may have had 3 or 4 different corporations, but I still own, ladies and gentlemen, the stock. And under the law, the creditor can reach the stock. They can take the stock of the company. So therefore, now I don't care if it's McDonald's stock, IBM stock, GM stock, or Harry Co. stock. They take Harry Co. stock. Now they own the company. They control the board. They can now sell my company to a third party. and liquidate the assets. They can liquidate the assets that are inside. They can clean out the bank accounts. Everything I worked all my life for was just lost because of a liability, not from within the corporation, but a liability from without the corporation to the owners of the corporation, and we lose that. Ladies and gentlemen, that is awful. And it's also unnecessary. In the vast majority of cases, we can fix that. So that can never happen to you. And I'm going to spend the next few minutes talking to you about how that occurs. So why would anybody want to go to business or go to work every day, knowing that on that day, you could lose your entire company for a liability that came from the outside? Because your vicious dog at home took out the mailman, and now you lose your business. This is nuts. So we want to see how we can fix that. Now, in California, sadly, there are numerous types of businesses that are not allowed to be LLCs, but must be corporations. Doctors are examples, certain types of real estate people, certain types of licensees, armed guards, lawyers. So assuming that the business is allowed to be an LLC, if that business was an LLC rather than a corporation, this has nothing to do with its taxation now. All right. It can still be an S corporation for tax purposes, a C corporation for tax purposes, or a partnership for tax purposes. If my company, if Harry Brent Co. was not a corporation, but a limited liability company structured in an appropriate jurisdiction, even California is appropriate for a multi-member LLC, we would not lose our business. Harry would not have lost his business if my wife crashed the car on the freeway. The remedy that would have been available to that creditor was to place a lien, known as a charging order, over the distribution of money from my business. But the creditor will not get any managerial control. They will not be able to liquidate any assets of my business. They will not be able to force Brent and I to make a distribution. They will not be able to force Brent and I to do anything. So, wow, what a difference. So for anybody sitting there that's an S corporation, C corporation, if we can turn that into, or through the use of a holding company, turn that into a protected entity for a downside liability, you have gotten your money's worth from this LSL webinar today. We probably do about 150 of these a year, very successfully. And there are no, I repeat this, when done properly, known as a plan of reorganization, no adverse tax consequences to you. You are the same entity for tax purpose as you were beforehand. But also understand that an LLC, when properly structured, is the Swiss Army knife of entities. It could be taxed in many different ways. It could be used as a charitable LLC. It could be used as a family LLC. It could be used as a real estate LLC. It can be used as an insurance LLC. There are so many different ways to deal with that. So I think one of the things that we all need to look at, and it can hold stocks and bonds and cash and real estate and other types of assets, is it an appropriate type of entity? What can we put inside of it, and how do we best structure that, and in what jurisdiction to best protect our assets from the claims of third-party creditors? Strong recommendation is to have that evaluated. It also, today in California, it is the only type of entity structure that could possibly be used under the new California Proposition 19 to move real property from one generation to the next generation, using certain exceptions without a reassessment on a highly valued or highly appreciated property. So it has a tremendous amount of opportunity that's associated with it. The members can have a voice in management as compared to a limited partnership. The manager of an LLC has asset protection, doesn't have unlimited liability like in a limited partnership with a general partnership, and it doesn't have, if structured properly, all the need for meetings and the need for board of directors meetings for the entity that we have in a corporation. So it can be taxed in different ways. Now, as far as LLCs are concerned, it's a great tool to hold real estate. For the same reasons, if we have a landlord-tenant liability, it'd be limited to the equity in the property that's inside the real estate and not your entire net worth and getting it done. But what else have we seen? Even for people that have structured proper limited liability companies or have changed their corporate structure to reorganize, we'll call it, their corporate structure into appropriate LLCs, we then begin to see too many eggs in one basket. We'll have a rental property that's in there. And over the years, they've been accumulating all the rental income. So not only do they have the rental income, but we also have a very, very large bank account with that they've invested in some securities or treasury bills. So there's still too many eggs in one basket. So we've got to show you how to offload some of those assets into another protected entity. So we could use LLCs to segregate assets. Now, let me explain something that is a question that many of you may have when we talk about jurisdictions. So I want to cover, I have a few minutes left and we'll do some Q&A. I want to cover some jurisdictional questions and we'll talk a little bit about that. So we all hear that, we're in California people are recommending a Nevada LLC, a Delaware LLC, a Wyoming LLC here in California. Does it work? Okay. So I think it's very important first to understand the nature of the assets that are inside the LLC. So if it's stocks and bonds and cash, I think it's fine. If we have a bunch of real estate that exists in California or businesses that are in California, and we have for example, a Delaware LLC that we are now authorizing to do business in California. If we're in California with our property, or in California with our businesses, we must authorize our business in California, pay California tax on that. But what we are looking for inside, it's the same, guys. It really is very basically the same. I think it's a little bit more difficult to pierce the veil of a Delaware entity than it is a California entity, but basically the same. It's when the outside. So my wife crashes the car on the freeway and they're trying to get in. At the beginning, they all look the same. California, Delaware, Nevada, Wyoming, all look the same. You get a charging order. You get a lien on distributions. But interestingly enough, if you're taking salaries because you're an S corporation for tax purposes and you are an LLC for legal purposes for asset protection, although you're not taking distributions, you're taking salaries, the only thing a creditor can reach is 25% of the salary in the state of California. So we have money that's coming out of the LLC and no distributions being made to the creditor. And that's a really good thing while we try to negotiate a quick and easy settlement. The difference is that in some of the other states, the only remedy that's available is something which is called that charging order. That's the only remedy that's available, that lien. In California, there's a secondary remedy that basically says, hey, look, I charged your interest. I'm the creditor. I charged your interest. You haven't paid me anything. You made any distributions in 3 years. So I'm now going to go to the court and ask them for foreclosure of that, of your interest. So even if they did that, which by the way, we don't see very frequently in California, what will happen there, and if they apply California law, is that the creditor will get the economic, they still don't get any managerial control. They still don't get any distributions. They still don't have the ability to liquidate any assets. So it's not a very good remedy, but it comes with a stinger for sure. Now listen to this carefully. If the creditor takes that secondary remedy, which is available in California, and does foreclose 3 years later because you paid nothing out under the distributions to that creditor, then the creditor for sure will get the income tax ramifications with that. They will pay the income taxes on the money that you don't distribute. I'll repeat that again. They will pay the income taxes on the money they don't distribute. And when their lawyer tells them that they're subject to a significant income tax liability, all right, usually the claim gets settled. In a case that we have right now, a plaintiff is trying to foreclose out against a California LLC that has $5 million worth of assets in it, mostly two pieces of appreciated property that cost $1 million. There's $4 million worth of gain. And if they foreclose, we have just let their attorney know. If they foreclose, our client is going to sell those two pieces of real estate. That will trigger a $4 million capital gain, which will be paid. You hear me? Paid by the plaintiff's attorney. I mean, the plaintiff, not the attorney. The attorney let them know that the plaintiff will have to pay $1.2 million worth of taxes without any way to get the $1.2 million. I do believe we are now in the process of settling that claim after 3 years that was unable to be settled before. The weapons that are available in appropriately and properly structured entities are critically important. So there's an awful lot. We won't get a chance today, Jill and Cami, to cover the estate planning tools that are used for asset protection and how we protect the second generations. In doing it, very, very important. We'll be more than happy to come back to LSL and do another webinar on that. But ladies and gentlemen, there's hours and hours of stuff to talk about here. That's why Brent and I and the team are willing to answer any and all of your questions. We'll answer some now, but we have providing a private complimentary consultation for each and every one of you. Take us up on it. This is not child's play. This is critically important. I hope I made the equation today. I hope you understand everybody wants to protect their assets, and sometimes it's really worth the rules, restrictions, and the costs associated with it to make you be able to sleep better at night and protect that which you've worked so hard for. So Cami and Jill, if we have any questions, it's a really good time to bring them up and let's see what we can do and get them answered.
We have lots of questions, Harry and Brent. So first, can you speak more to the liability of a spouse from a business transaction that occurred before you were married, but is currently in litigation?
Yeah, if the facts that gave rise to the liability occurred before marriage, then only the spouse's separate property is liable for that claim. I don't think that the other spouse's liabilities for that claim, but it gets messed up a little bit because if it's a business litigation, if it's against the person, it would be the separate property spouse, and one half of the community property would be subject to that claim, but the other spouse's half of the community property and their separate property would not be involved. But we want to make sure that somewhere along the line that the community was not gaining an interest in the separate property assets. But that's beyond the questions that we can answer in today's questions and answers. But it should be separate. Their separate property and one half. Just because they got married, the new spouse doesn't necessarily get involved. But they should have had a prenuptial agreement clarifying that anyway.
So if someone asked a tax question, and keep in mind, Dave Myers will be covering the tax implications of LLCs in his presentation coming up on June 13th. But the question was, can you have the company be an LLC and be taxed as an S Corp?
Yes, absolutely. It's all the time. Matter of fact, when one is already an existing S Corp, we reorganize it into an LLC and keep it as an S Corp for tax purposes, so as not to have any adverse tax consequences. An LLC, as the Swiss Army knife of entities, can be taxed as an S Corp, can be taxed as a C Corp, can be taxed as a partnership, and under certain circumstances could be a completely disregarded entity for tax purposes by federal law.
Next question, does a private retirement trust provide superior asset protection versus LLC for investment real estate?
The answer to that question is yes and no. Typical lawyer's answer. So a private retirement trust, if you had 5 pieces of real estate inside a private retirement trust, and we have a liability that any one of those 5 pieces of real estate, I would sue the private retirement trust for the liability. So all 5 pieces of real estate and all the assets in the private retirement trust would be subject to that claim. Nutsy cuckoo. So even though we have a private retirement trust, which is looking to protect the outside in liability, each of those pieces of real estate should be segregated. So the private retirement trust should be owning 1, 2, 3, 4, 5 LLCs to get that interior asset protection, which is critically important. So the question kind of begs the question. We still need LLCs inside the private retirement trust because it doesn't shield the owner from liability. The other question is does it protect, the other side of it is, so Brent crashes the car, he has a private retirement trust. Can I get into the private retirement trust and liquidate his real estate? And the answer is, if it's done properly, and it's a very tough question in California, we do private retirement trust. More likely than not, yes, it would be protective. Would it be more protective than an LLC? Not necessarily so, but it could be more cumbersome. But it's really important, though, is the moment that Brent moves out of California with everybody else and leaves for Texas, Nevada, or someplace else that he wants to go to, all of the asset protection is lost. It's exclusively a bird of California law. And the moment you move out of California, should you move out of California, that private retirement trust is no longer protected.
Thank you, Harry. Next question. What is the fee range for creating an LLC, and do I need more than one?
Well, the answer to needing more than one is really a business question. So let's answer that one first. So if I had 4 pieces of real estate and each one had $1 million worth of equity in it, and I put all 4 into one LLC, now that LLC, which is now the landlord, has a $4 million net worth. So that's not really smart. And then if I have a liability at property 1, 2, 3, or 4, it takes down properties 1, 2, 3, and 4. So I have more chances for liability from more tenants, from more guests, from more invitees against a larger net worth. So what did you save? You saved the formation of a few LLCs and maybe $800 a year in annual cost. All right. You didn't, which most likely could be passed through to a tenant, and you didn't get the best. So the answer is, could you have more than one? Sure. Could you have 2 in one? Yes. Could you have 1 in one? Yes. That's a business decision. But if you pack too many eggs in one basket, you kind of recreate the problem all over again. And that we help people see that through the fog of legalese. The cost of setting up an LLC on the average is a couple $1,000s. But remember, setting up an LLC is not just an LLC formation. So you have to set up an LLC, and the magic to the LLC for asset protection is in the quality of the operating agreement and the rules and regulations in the operating agreement, which are designed for asset protection, that should be written properly. Its structure should be manager managed, should be member managed. We have to make sure that the LLC is held by the living revocable trust. We have to also make sure that when we transfer the property into the LLC, that it's done properly so that the assessor's office doesn't reassess the property in California as a change of ownership. So there are a lot of things that have to happen. Tax ID numbers have to be made and guidance. So it's not just the formation. I think almost anyone could file the articles of organization of an LLC, but that doesn't necessarily mean we have a quality asset protected LLC. So you may save a couple of bucks by doing it yourself, but in the end, it could cost you a fortune.
Next question. If we already own an LLC, is it possible to move all equipment owned into a separate LLC? Does the new LLC need to purchase the equipment from the original, or is it possible to transfer and still remain protected?
Okay, so that's a really good question. So it's a really good question in a couple of different ways. So the one question is that maybe I hit home a little bit, that maybe we should have the equipment in a separate entity and lease it to the operating entity. That's smart, good business, good taxes, great asset protection. So a liability of the operating company doesn't take down all our valuable equipment. But it depends on how, now that equipment is in the operating entity, how we get it out is interesting. So if the original operating entity is an LLC that's taxed as a partnership or as a disregarded entity, we can move all the equipment out of that entity into a new entity without any adverse tax consequences whatsoever. We actually reverse it a little bit. We kind of leave the equipment in the old entity and create a new operating entity. A little easier to do without moving all that equipment around. And that works very, very well without any adverse tax consequences. However, if the LLC is taxed as an S corporation, that doesn't necessarily work. In that case, because then if we pull the equipment out without a sale, then that's going to be a taxable event. So one of the best things that we could do is to create a new parent have two subsidiaries, one for equipment, one for operations, and we can just do it that way without any tax consequences. Other than that, if it's a corporation and you want to set up another entity, then that new corporation would need to buy that equipment from the old co. I would rather turn around and set up a new operating company, because if we buy the equipment from old co, there could be some capital gains or depreciation recapture on that, and there could also be other tax ramifications associated with that. It can be done, and sometimes it can be done effectively. But sometimes what we look at that is saying, depending on the nature of the equipment, Jill, the equipment depreciates, eventually is done, and then it's going to get replaced. So new replacement equipment, we'd buy it in a new entity and lease it to Oldco and just let the other one move out on its own. But it's really something that's very fact sensitive that has to be evaluated on a case by case basis.
We have several more questions. Do you have time for one more? Or
I have time for 2 or 3 more.
Okay, great. So the next one is there an automatic step up in basis for 1031 DSTs held by my S Corp on my death? The S Corp is in my revocable trust.
To the best of my knowledge, the answer is yes.
Okay.
That's a good question for Dave Myers, though, not for me.
Got it. Okay.
If I wanted to be accountant, Jill, I would have been one. We'll leave that to Dave Myers.
We shall. And he will be presenting again on that June 13th. Let's see, I'm sorry. If you purchase a rental property in your name and then subsequently create an LLC for asset protection purposes, how do you move the property into an LLC without triggering the due on sale clause? I think you might have covered that.
Yeah, so that's a really good question, and it's changing a little bit in time. So over the last 10 years, before we had this giant increase in interest rates, nobody seemed to care. So what would happen is we would deed the property out of your living revocable trust to your name and into the newly formed LLC, and nobody seemed to care. So I would say 99% of the time we had absolutely no issues with lenders whatsoever. And especially if you're dealing with residential properties, there's some aspects of the law which prevent lenders from defaulting. But here's what we found. Now, recently, there's more incentive for them. So, hey, look, you got an interest rate of 3%, new interest rates are at 7%, and they tell you, well, if you transfer the property that we have in your name into an LLC, we're gonna, call the note, and you're gonna have to, reapply and pay 7% in fees. So let me give you my batting average on that, Jill. It's at 1,000. So I call the bank, or Brent calls the bank or the lending institution and say, hey, look, to me, it looks like your collateral, your equity in that building or that piece of real estate has just been protected from other creditors other than you. You have complete control of that. You have the security interest against the real estate, and we have kept other creditors out from hurting that equity that you have. So to me, the lending institution is in a better position than it was before. And also remember that 3/4 of them, Jill, if not others, have sold those loans off to somebody else, 5 different ways from Sunday. They don't even have it in their own portfolio. And almost universally, we have no problem getting lenders' consent to the transfer to the LLC. Remember, the liability that you signed for personally will run with that real property. So there is no detriment to the lender whatsoever. So pretty good on that. We'll see, but we have some other alternatives I didn't have time to discuss with today. Should a lender really become a jerk and not allow that? At worst, we've seen maybe they want to charge a $500 or a $1,200 fee for all their paperwork. Really well worth it, but most of the time it's literally not a problem.
Okay, and our last question we have time for is, can you speak to the strategy of having LLCs that are owned by a holding company partnership rather than a trust? Is it more beneficial for asset protection?
Well, the answer to the question is the question is not, how do I put this? Is not a good question in this respect. The holding company, an LLC held by holding companies, we do a lot of those. We may have 5 properties, 5 single member LLCs held by, for example, a Nevada holding company. That's great asset protection unto itself. But then that holding company needs to wind up in a trust. So either can wind up in a trust which is a living revocable trust to avoid probate and other estate planning issues, or it can be held by an asset protection trust, which is the gold standard. So the gold standard is you have an asset protection trust, which holds the holding company, which holds the underlying single member LLCs. Great protection from the outside, difficult for creditor even to get a charging order, in that a very, very, very good structure when done properly. So it's kind of a combination, not either or, it's kind of a combination of. And with that, Jill, I think
That'll
we
do it.
it was great being with you and all of your people today, and I look forward to it. And here's our contact information. You could reach out to Jill at LSL. You can reach out to Brent, reach out to me, and we'll be more than happy to spend a little time with you. And those who want to just jot down real fast, the phone number 714-704-4828. And call, just say you want to request a consultation because you attended the LSL webinar, and we're more than happy to do it. Leave your checkbook home. We can answer all the rest of the questions. So Jill, Brent, Cammie, and Dave, thank you all very, very much. We look forward to speaking to your group again in the very near future.
Thank you
Thank you guys
so much. And just for all of you, just remember, we are going to send out a link to this recording later today. It will also have Brent and Harry's contact information for you. And don't forget, part 2 is entity selection from a tax planning perspective, and that will be hosted by LSL partner Dave Meyer on June 13th. So be on the lookout to register for that. And with that, we will let you get to your day. Thank you so much for attending today, and make it a great day, and we will see you next time. Take care. Bye-bye.